May it please the court, my lady, I appear for the applicant with my learned friend, Ms. Johnson.
Thank you.
And now for the accused respondent, my lady.
Thank you very much. Yes, Mr. Mayor.
May it please the court, my lady, may I just start by saying it's never an easy task to bring an application for leave to appeal. From where I'm standing, my lady, it's an exception for the state to bring an application for leave to appeal. It's my first. And, my lady, I just want to say,
You're not the only one.
same for the court. May I just say that at the outset, we do it with the utmost respect to the court.
No. That's it goes without saying.
Yes. So we have to go into errors and so forth, my lady, but we do it with the utmost respect.
Yes.
And it wasn't a decision that was lightly taken. My lady, may I then... also, my lady, I had a quick discussion with Mr. Roo. This is an application for leave to appeal. It's not that we're arguing the case again and so forth.
Yes.
I will try and just focus on the issues at hand and not expand too much on it, my lady, as my duty or my obligation is just to try and convince the court that another court may make a different finding and not to convince the court that the court was wrong in any other way. And I say it with the utmost respect.
Yes.
But lady, then there are two applications before the court. The one is in terms of Section 316 and the one is in terms of Section 319. May I proceed, my lady, with 316? That's a sentence.
Yes.
My lady, I will go through our heads quickly, but in summary, my lady, we acknowledge the test applicable for a court of appeal to interfere with a sentence. We understand that it will not happen easily, that we have to indicate that there's a sentence either shockingly inappropriate or that there was a misdirection by the court of quote. We understand all that, my lady. We're also not saying, my lady, that the court did not deal with the principles regarding sentence in the judgment. What we're saying, my lady, is that although the court dealt with the principles, the weight attached to the principles was incorrect, my lady, if one look at the sentence and look back. That the sentence is for what the accused did is shockingly inappropriate and does not fit the crime and the accused. My lady, may I then, whilst I'm summarizing, we will argue that the respondent erred by referring the court to facts that happened subsequent from the application. And we refer to case law there, and that's clearly an error, my lady. Then we will say that although the court dealt with the evidence of Vergeer and remorse, the court did not really take into account what we said is that the accused did not have remorse, my lady. Then we will focus on the consequences. We say that not enough weight was given to the consequences of the accused actions. And, my lady, then we're saying that there was a misdirection with respect in that the court did not take account of the fact that in terms of Section 2761I, the accused would only serve an incarceration period of 10 months, and that is shockingly inappropriate to what the accused have done. My lady, then perhaps the main argument...
Is it not in the discretion of the commissioner?
My lady, in terms of the regulations, it's 10 months, my lady. It's a discretion. It can happen, but discretion the commissioner will look at the accused situation after 10 months. So, in fact, my lady, that's what we say it amounted to. And perhaps, my lady, the main argument, and I will go through it, is the following. If this court found that the accused acted with gross negligence, that bordered on dolus eventualis, and that a sentence of 5 years in terms of 276I is appropriate, what precedent does it set, my lady, for other kinds of, for lack of a better term, less negligent cases? Because this, my lady, must be at the top end. So what we're saying is, if the court applied Ngumalu, the principles in Ngumalu, where Ngumalu clearly said that for purpose of sentence, one will be guided by the degree of negligence. Now, my lady, if the degree of negligence in this particular case bordered on dolus eventualis, and if the finding of the court, which we agree with for purpose of sentence, is that he was grossly negligent, my lady, then the precedent set by this court is shockingly low, that somebody that acted with that degree of culpability would be sentenced to 5 years in terms of I. What about, and we mentioned it in our heads, my lady, what about the man in this instance that fired shot and there was indeed an intruder in the toilet? Where would that have been, my lady? If where an innocent person was in the toilet, it was at 5. What, my lady, if there was an armed intruder and he was shot under circumstances that a reasonable man would not have done that? Where would that go, my lady? Because that must clearly then be less. So what we're saying, my lady, is that in terms of sentence, for what this accused have done, and for purpose of the consequence of his actions, the degree of culpability, the sentence is shockingly inappropriate. My lady, I've now summarized my heads. I'm going to page through them, my lady, and just mention one or two aspects. My lady, then, as I said initially, it is not for me to convince the court that the sentence was inappropriately light or that there was a misdirection. It is for me, my lady, with the utmost respect, to indicate to this court that there's a reasonable prospect that the Court of Appeal, in evaluating the circumstances of this case and the facts of this case, may come to that conclusion. My lady, we deal in our heads, page 1, with the applicable rules that for intervention in a sentence. My lady, we deal. We have filed our heads yesterday, my lady.
Yes, yes, sir.
And filed on the defence. In paragraph 4, my lady, we deal with the degree of negligence, and we say there, my lady, the precedent set by this honourable court is that sentence for gross negligence and conduct that bordered in dolus eventualis deserves no more than 5 years imprisonment. Then we say, my lady, at the bottom page of page 4, what should the proper sentence for mere negligence be? If the top end is 5 years. At page 5, my lady, paragraph 5, we indicate that the principle relied upon by the respondent, that the test applicable to appeals is that a court may have proper regard to events that occurred subsequently to the passing of sentence, is clearly wrong, my lady. The case law referred to by the respondent clearly states that only in very exceptional circumstances will a court of appeal have regard to events that occurred after sentence. And none of those exist, my lady. There's nothing exceptional that would allow the court or convince the court to take account of what the parent and or advocate of the family thought about the sentence, my lady.
But is that relevant in any event?
Not at all. But it was mentioned, my lady.
Yes,
it was mentioned in the head. It was used to oppose our papers. And we're saying that it is irrelevant and should not have been mentioned. My lady, on the comment that the court just made to me, I agree with that. I'm not going to belabor that point any further. I deal with that point fully, my lady. Then, my lady, as far as... we have to apologize. There was a typing error in our heads. And we do that at paragraph 9. In our heads, we refer to the sentence for murder, my lady. It was clearly a typing error. We can do no better but to apologize to this court that a typing error
it happens.
found its way through
Yes, yes.
up to your desk. My lady, then we deal in paragraph 10 with the court's and how the court dealt with Vergeer's evidence. We say that the court, in fact, correctly, my lady, rejected Vergeer's evidence. But the one aspect that perhaps the court did not give enough weight to, my lady, is that Vergeer was led by the defense about the conditions in prison. By the defense, by the respondent. And the respondent placed before court the fact that prison would not be suitable because there are no railings in showers and baths. Just to later establish that neither did he have railings in showers and baths at his house. Now, my lady, that, I say, with the utmost respect, indicates that we're not dealing with a person that wanted to take the court, and I deal with it at page 8, my lady. This did not create an impression of the respondent as someone with remorse trying to assist the court in its difficult task of arriving at an appropriate sentence. That was an extension, my lady, of his attitude during the trial, in that is, he would do anything. The truth and where this should be placed is not important. That, my lady, that he would present evidence to this court that he cannot go to jail because of this is an indication, my lady, not of somebody that said after the conviction, I have remorse, I want to assist the court. That must negatively affect on his remorse. My lady, so much so, and I'm not saying that the court made much of remorse. My lady, I quote the court here. The court said, he seems remorseful. My lady, but this would indicate that, well, his remorse did not carry through as far as sentence is concerned. My lady, as far as the consequences is concerned, and that we deal with at paragraph 11, we say, my lady, the consequences of his actions did not carry enough weight with the court in arriving at the sentence. There was an innocent woman shot and killed in the most horrendous circumstances. The court took into account that she was shot and killed, my lady, but it is not an instance where a shot was fired and somebody died. It was an instance, my lady, where somebody was in a very small cubicle whilst 4 bullets were fired through a door under conditions where the deceased must have been unbelievably fearful before she died. And it was caused by the gross negligence of this respondent, my lady. My lady, for purposes of sentence, we acknowledge that the court made a finding that the accused acted in putative self-defense. But we say, even with that, my lady, the consequences of his actions should have received more consideration. My lady, we deal with the summary, the court summary of his actions, and we deal with that at page 10, my lady. The court found, and my lady, that is the consequences of his actions and his gross negligence, and the facts that should have be foremost in the decision on a sentence, and that is the respondent knew there was someone in the toilet. He knew that. He deliberately fired 4 shots into the door with the aim of shooting the intruder. The accused knew that the toilet was a small cubicle and that an intruder would have no room to maneuver or escape. Now, lady, just that. if someone would, let me say, if someone is convicted of culpable homicide, having fired 4 shots into a cubicle in his own house, where he knows that that person would not be able to maneuver or escape or was not coming out, my lady, certainly that deserves to be punished, those actions. It's not somebody that fired blindly or fired in a direction or didn't know where the person was. He knew, my lady. We say, my lady, even more devastatingly, the court found that the respondent was trained in the use of firearms and that a higher degree of responsibility in the use of firearms is required from such a person. We're not dealing with a person that just grabbed a gun and fired, dealing with a trained person. And then, my lady, we incorporated in our heads the list in our application for leave to appeal. My lady, then, may we deal with mercy? My lady, I argued mercy, and I'm not going to re-argue mercy, but I understand mercy. I mean, it's crystallized all over sentences that the court will have some mercy. My lady, but there could also be an instance, and I say this with the utmost respect, where too much mercy is shown to an accused. Because, my lady, if one take into account everything that was just said, that the court summarized, then the court said, but the court correctly said that an appropriate sentence should include an element of mercy. And, my lady, if that mercy is that the court would say, I think that the suitable sentence is 10 years, but now I have to be merciful, now it goes down to 5, then clearly, my lady, that would be a misdirection. My lady, if I read the judgment, and I say it with the utmost respect, if I read the judgment, the court said that because of everything, because of the consequences, because of his actions, because of gross negligence, sentence, a non-custodial sentence is not appropriate. And then the court applied the mercy principle. My lady, based on all the facts, we say that perhaps the element of mercy was over-exaggerated. And we quoted at page 11 of our heads, my lady, where the court said, a non-custodial sentence would send out the wrong message to the community. On the other hand, a long custodial sentence would also not be appropriate, as it would lack an element of mercy. Now, my lady, what we're saying is, if the court would ask me what I think a long custodial sentence would have been, I would have said 10 years, my lady. Now, if it is 10 years and this accused ended up, when mercy was applied, with 5 years in terms of 276, I respectfully say that was a misdirection. Because, my lady, although the court said that a non-custodial sentence would send out the wrong message and that an element of mercy should be applied, the court then imposed the shortest reasonable period of incarceration that the court would be able to do. And I say reasonable, my lady. I've really tried to think what other sentence of incarceration would have been less lenient than 10 years, my lady. 10 months, my lady. And nothing comes to the fore. Except because the court wanted the element of custodial sentence to be applied, my lady. Did the court want the shortest possible period for gross negligence and what's the other word? Gross negligence and actions bordering on dolus eventualis to be applied to. My lady, we say that with the utmost respect to the court, a court of appeal, having had regard to the way the court dealt with sentence, the way the court summarized correctly, my lady, the way the court summarized what the accused did, that we have no problem with. We agree 100% with that. But if that is applied to the end result, which is the shortest possible incarceration, then, my lady, it's shockingly inappropriate. and we say that, my lady, we say it's shockingly inappropriate. My lady, I do not have to convince this court that it's shockingly inappropriate. I, however, say that there is a very good prospect that we may convince the appeal court that the shortest possible period of incarceration in a situation like this, my lady, is shockingly inappropriate. And therefore, my lady, we say we've made out a good case for leave to appeal on sentence. May I proceed with 319?
Yes, you may.
Lady, and again, as far as 319 is concerned, we filed heads. As far as Section 319 is concerned, my lady, there are a few hurdles that I have to cross. I'll mention them all and acknowledge them, and I will deal with each one. The first one, my lady, is the Siakui hurdle. We will deal with that. The second hurdle is the question that should be reserved for the Supreme Court of Appeal. I see the Act wasn't changed. If one reads 319, it still refers to the appellate division. But I mean, I think we all understand that it's now the Supreme Court of Appeal. That it should not be merely an academic question. It should be a question that, if answered in the affirmative, would have an impact on judgment. Third hurdle I have to cross, my lady, is that are we dealing with a legal or factual question? And then, my lady, those are the hurdles I have to cross. The things I will discuss and will make submissions to the court where we feel that the court may have erred, my lady, is the application of dolus eventualis to the facts of the matter, and particularly, my lady, where the court found that accused acted with putative self-defense. Particularly there, my lady. We will address that and say that the court erred in applying the principles of dolus eventualis. We will continue, my lady, to say that the court erred in not taking into account, as the court should have, all the circumstantial evidence that the state presented. And, my lady, with the utmost respect, that the court, in dealing with circumstantial evidence, applied the principle of evaluating each piece of circumstantial evidence in isolation. And the court did not, as the court in 44 Appellate Division de Villiers said, that one should look at the circumstantial evidence as a whole. My lady, we say that in this particular instance, with utmost respect, my lady, that the court did not do that. This principle was, we tried to argue a mosaic. In the past, my lady, it was said that a piece of circumstantial evidence is but one feather on the scale, and lots of circumstantial evidence will weigh much more than one particular one, and to take that off and to weigh the next feather and take that off the scale and to weigh the next feather. And then, my lady, we will, with utmost respect, argue that the court erred, with respect, my lady, in finding that the accused version was reasonably possibly true, because the court rejected his version. He had a version, an elected version. He had an alternative argument. But, my lady, we say that the principle in law is correct, that even if the court would not believe an accused, the court can still find that his version is reasonably possibly true. But in this instance, the court rejected his version and said, I will now look at an alternative, that's a mutual destructive version. If that's not reasonably possibly true. And we say the court erred, my lady. The court can only, with the utmost respect, evaluate the accused version as reasonably possibly true on its version. Not, my lady, elect a different version, and then in the process, my lady, with the utmost respect, construct a different version. And we say that the court erred there. My lady, may I start? We will also, my lady, then, in our argument, deal with the conception and application of dolus evangelis as applied, my lady, in scenarios of error and objector. And we will indicate that in our respectful submission, the court erred. My lady, may I start? And I'm not going to read through my heads, but I will just touch on the sequi hurdle. Now, the sequi hurdle I deal with from page 34 of my head. Paragraph 34. May I say at the outset, my lady, when I started with this application, and when I was confronted with sequi, it struck me that sequi has been followed by our courts over a period of years. And when I evaluated sequi, my lady, I cannot understand that we followed sequi. Now, it was followed, my lady, I say, up until Basson, where where the Constitutional Court in Basson clearly indicated that Section 319 should be more widely interpreted, and not only in instances where someone was acquitted. My lady, then, and I make mention and acknowledge the input by academics, my lady, because I've never claimed to be an academic, my lady, but I have, and I've acknowledged the assistance we received from Professor Grant. May I just take the court through our argument on sequi? Sequi's main argument is, if the court would refer a question, reservation of a question to the appellate division, where an accused has been convicted of a competent verdict, the Court of Appeal would have only one option, and that is to make a finding that the case should be retried, which is clearly not correct. It's clearly not. It's not the only option available to this court. This court has a discretion. Now, I find it, when I read it, and therefore, my lady, please allow me just to stand still and to share the insights I got, my lady. Now, in sequi refers to Ghani and says that in terms of Ghani, the only option available for a court of appeal would be to order that accused is that there's a fresh trial. But a mere reading, my lady, of section 324, 3224, my lady. Sorry. And I deal with that at page 38. My lady, I've now run through the heads by saying that at page 38, paragraph 38, my lady, sequi refers to Ghani. Now, Ghani did not support sequi at all. Ghani clearly indicated that the court has a discretion, whereas the court in sequi accepted that the court has no option but to order a new trial if the Court of Appeal makes a finding that the court of quo wrongly decided the point of law. that is not true, my lady. And then when I read 3224, and I quoted there, the Court of Appeal may order that such of the steps referred to in section 324 be taken as the court may direct. Now, my lady, if one just take account of section 322 of the criminal procedure. Now, firstly, my lady, it indicates that, if I want to build my argument, SABC indicates that the court will have no option but to found that there should be a new trial if the appeal court finds that the court of quo wrongly decided upon the law. They refer to Ghani, which clearly does not support that particular finding. A mere reading of 3224, my lady, does not support that interpretation at all. Because, my lady, at page 38, if I can ask the court to just turn the page, if the court sees that page 38, just turn the page, still paragraph 38, we say, respectfully submit that the court in SABC misread Ghani. The court in Ghani did not find that the only course open to a court under equivalent provisions of section 3224 was to order a retrial. It says that the court is not obliged in every case to order that such steps be taken, but without such an order, fresh proceedings in respect of the same offence could not be instituted. And then we say, my lady, an order in terms of section 3224 is a necessary order, but not a sufficient condition. It's a necessary condition for a fresh trial, but not a sufficient condition. My lady, and then what we then did is we just, because the question would now be, what can the court do? And we then read section 322. Now, 322, my lady, of the Criminal Procedure Act reads, in the case of an appeal against a conviction or of any question of law reserved, the Court of Appeal may allow the appeal if it thinks that the judgment of the trial court should be set aside on the grounds of a wrong decision of any question of law, or that any ground there was a failure of justice, or give such judgment that ought to have been given at the trial, or impose such punishment as ought to have been imposed by the trial. So there is an avenue open, my lady, which is not only a retrial. Now, my lady, if that is true, if our interpretation is correct, SABC should not be followed, my lady. But, my lady, we have to follow SABC because that's, we say, that the fact that the Court of Appeal would have no option but to order a new trial was the main obiter dictum of the decision in SABC. But, my lady, I've got to, my lady, I'm not an academic, but I've got an academic next to me that will make sure that I use the correct terms. My lady, may I refer the court in SABC? My lady, it's a very Afrikaans decision. So I'll try and translate as far as I can. But I'll tell the court where I find this. At page 103, my lady, where Appellate Judge Rabi starts with, where he says, dit wil sê dat 'n herverhoor die enigste stap is wat die appelhof kan beveel. As daarmee rekening gehou word, kom dit heel onwaarskynlik voor dat die wetgewer sou gewil het dat so 'n stap gedoen kon word in 'n geval waar 'n beskuldigde inderdaad na verhoor skuldig bevind is. Maar lady, it's just what we said. The court said, because the Court of Appeal has no option but to order a retrial, it could never have been the intention of the legislature to have a retrial where somebody has been convicted of a lesser charge. But, my lady, we clearly said that that is not applicable anymore. The court then, my lady, in Sekwe, dealt with the question, what is a competent verdict? In our case, what is count one? Now, in Sekwe, the court said that count one is in fact one charge with different possible results or convictions. But clearly that's not it. And there this court was 100% correct. This court did not deal with count one as one charge with different possible convictions. This court dealt with count one as murder and other alternative counts. We're saying, my lady, that the Criminal Procedure Act, in listing competent verdicts, just made it easier for the state and for everybody to understand the law, and for the state not to have to, in every instance, indicate all the possible alternatives. Now there's an indictment, there's one count, we all understand what the alternatives to that one count of murder is. But this court was correct, my lady. This court acquitted the accused on murder. Whereas if it's one count with different possible convictions, this court would just have said guilty of culpable homicide on count one. But this court didn't. This court, in fact, acquitted the accused on count one and said instead, those were the words used by this court, instead he's convicted of culpable homicide. So, my lady, clearly, the understanding of the appeal court then about competent verdicts, my lady, we do it with the utmost respect, but you don't agree with. It cannot be one charge. Because, my lady, if one just has a look at what is there, if you charge somebody for murder, a competent verdict is public violence. Now, that can't be one count. It can be an alternative. Now, my lady, if that is true, that we're dealing with one count with possible different convictions, then, my lady, certainly the court can convict somebody of culpable homicide even if murder was proven. Because it's one count. But that can never be. If murder is proven by the state, the court is bound to convict somebody on the count of murder. It might be an academic argument, my lady, but it is significant in evaluating Sekwe. Now, firstly, we say the first issue of Sekwe, we've given the court our understanding. The second one is understanding of competent verdict that wasn't shared by this court. The third issue dealt with is, and I'll read it in Afrikaans, my lady, and then do my utmost to translate it. 'n verdere oorweging wat myns insiens teen die gedagte spreek dat daar in geval soos die onderhawige herverhoor beveel kan word, is die volgende. Daar bestaan 'n skuldigbevinding. En die appelhof sou nie 'n herverhoor kon gelas nie tensy hy die bevoegdheid het om terselfdertyd die skuldigbevinding tersyde te stel. So, what it's saying is, because there's a conviction, the appeal court will not be able to even ascertain this appeal and or order a new trial without being in a position to set aside that one conviction. But it's neither here nor there. The accused was convicted of a lesser count. If the court in terms of 322 can give the decision that the court of course should have given, that cannot be an issue, my lady, that would prevent this court from applying 319. My lady, the other aspect, and if I could just finalise my argument here, there is no appeal in Sekwe, if Sekwe is correct. If Sekwe indicates that not if Sekwe is correct. We're not appealing, my lady, the conviction of culpable homicide. We're appealing the acquittal on a point of law, on murder. So, my lady, the Court of Appeal would not have any reason to set aside, up until the time it makes a decision, the conviction of culpable homicide, because that is not what we're appealing. We're appealing, my lady, the acquittal on a conviction of murder. And, my lady, having read this in Sekwe, we then looked at 324, my lady. Where the court deals with the institution of proceedings de novo when conviction is set aside on appeal. Now, the section reads the following. Whenever conviction and sentence are set aside by the Court of Appeal on the grounds that, and it mentioned the grounds there. Again, my lady, clearly, Sekwe cannot be read into the provisions of the Criminal Procedure Act, where the Criminal Procedure Act indicates in 324 will only be applicable when a conviction and sentence are set aside. Then, my lady, I've now dealt with 3 issues as far as Sekwe is concerned. May I deal with the 4th? 4th, my lady, is and I'll read it in Afrikaans again. Herverhoor gelas. Now, let me start somewhere else. So vertolking hou die moontlikheid in dat in geval soos die onderhawige waar daar noodwendig heelwat tyd sal verloop van die tyd dat die verhoorhof die betrokke regsvraag voorbehou tot die tyd dat die saak in die appelhof verhoor kan word, 'n herverhoor gelas sou kan word nadat die beskuldige reeds 'n gedeelte van die vonnis of dalk die hele vonnis wat hom opgelê is uitgedien is. What the court saying there is, because somebody's been convicted and sentenced, by the time the appeal is heard in the appeal court, the accused would have served a portion of his sentence. Well, but that happens with every appeal. And not only an appeal where the state appeals. I mean, that is par for the course. That if there's an appeal, the sentence, somebody would start serving. And we're not, there's not, my lady, and when one evaluates this appeal, and specifically this point, there's not a counter-appeal by saying that the sentence is too harsh, that the accused would be entitled to a lesser sentence, or an appeal saying that the accused should have been acquitted. We don't have that. So for purposes of this appeal, this application, we don't have that. We only have the state appealing saying there should be, just because I don't have a better word, but a harsher sentence and a harsher conviction of murder. So, my lady, that particular point of Sekwe is with the utmost respect not convincing. Then, my lady, the point I just made is, the court said in the 5th instance that the court used, it says, 'n vreemde situasie wat ook sou kon ontstaan indien die staatse vertolking van artikel 3224 gelees met 324 juis is dat die appelhof gevra kan word om die herverhoor van 'n persoon te gelas terwyl daardie persoon appel teen sy skuldigbevinding aanteken. So that's just what I'm saying. If there was an appeal by the accused against his sentence or his conviction, the legislature would never have intended the state to appeal an acquittal. Lady, firstly, I don't think it's convincing, I said, with the utmost respect, and secondly, it's not applicable in this particular instance. But what is, however, interesting with what I just read is in Sekwe, the court said one should take together and read section 322 and 324 together. Now, if one does that, it is clear that section 324 refers to when a conviction was set aside. Why I'm saying this, my lady, Sekwe say we are not allowed to appeal against a conviction on a competent verdict. We say, but then the court should never have referred to section 324 because section 324 clearly indicates whenever a conviction and sentence is set aside. And to read 322 4 together with 324 would be impossible. Because one just cannot do that. Because, my lady, why am I arguing this? 3224 reads, where a question of law has been reserved on the application of a prosecutor in the case of an acquittal, and the Court of Appeal has given a decision in favour of the prosecutor, the Court of Appeal may order that such of the steps referred to in section 324 be taken as the court may direct. And 324 clearly indicates, my lady, it's a conviction. My lady, then, that is only the first leg of the hurdle. But I say it again. When I read Sekwe the first time, I could, there's one other point I'll make, but let me just carry on. When I read Sekwe the first time, I thought, but not only is it unfair to the state, which everybody would accept that if something is unfair to the state, it is, but it doesn't make sense. Because, my lady, if I, in this instance, and nothing prohibits the state to do that, if we charge the accused with murder and culpable homicide in the alternative, except for all these smiles and laughs we would have received for having done that, it would have been absurd to say, if we did that, now, in terms of Sekwe, we had a right to appeal on the acquittal, on the main count, and so that would not have been a hurdle. So, lady, but what is interesting, I thought, but that must have been argued before. I can't be the first person that ever thought about that. And it was argued in Sekwe. But in Sekwe, the court said, I don't have to decide that. Which is, with the utmost respect, I criticize. Because that is the question. If there's a main count with alternatives, and somebody is acquitted on the main count and convicted of the alternatives, it just makes, with the utmost respect, so much sense that an appeal, in terms of 319, against an acquittal would be no hurdle. But at page, it's almost at the end of the decision in Sekwe, court said, dis nie nodig om in te gaan op die vraag of dieselfde posisie geld in die geval waar iemand op 'n hoofaanklag en sekere alternatiewe aanklag tereg staan en hy dan op 'n alternatiewe aanklag skuldig bevind word nie. Court did not the court decided court discussed it and said, I don't have to decide that fact. Lady, which is crucial. And if this court was correct in the court's approach to the conviction and the acquittal on murder, the hurdle in Sekwe would fall away. But, my lady, that's only one leg. The second leg is we had Bason, Constitutional Court. Now, my lady, in Bason, now, if one reads lady, it's indeed a pleasure to read Bason in the way that the Constitutional Court researched the history of Section 319 and how the Constitutional Court reached the finding that it did. May I continue? Later, I've just interrupted myself. I apologize. What the court did there, taking into account Sekwe said, the state will only be able to appeal in terms of 319 upon an acquittal. The court said no, it cannot be. It could never have been the intention of the legislature. The court then took into account what duties the Constitution confers on the state as the authority to institute criminal proceedings, and the court dealt with the provision of the Constitution that the prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings.
What page are you reading?
It's at page 618. Although Basson seems a really long read, it's not, my lady, for purposes of this. The court can start reading Basson at 318. 618. 618. At 619, my lady, what I read to the court is at the bottom. Also significant, my lady, is where the court said at 619 at D, one of the consequences of the advent of our constitutional democracy is the requirement that all laws must be construed in the light of the Constitution. This requirement flows from the supremacy of the Constitution. And then it says, my lady, that all old order legislation should be interpreted to be in line with the Constitution. The court then referred to the duties of the state in terms of prosecution, or in terms of the Constitution. And then, my lady, may I refer the court to page 620 at paragraph 145. It is plain from the legislative history of Section 319 that its purpose was, amongst others, to allow the state to appeal on a point of law by requesting reservation of a question of law. But I'm looking for one specific may I proceed, my lady? As far as the important things is concerned, I'll get to that specific passage that I want to refer the court to. It carries on at page 621, where the court deals with the legislative history of Section 319, makes it clear that it was intended to afford the state the right to appeal a question of law to the SCA. This right is incidental to the right of the state to institute criminal proceedings provided for in Section 1792 of the Constitution. But the question is, was it intended that this right is available only in limited circumstances? It was then answered. There are indications in both the language of 3191 and in the context in which a section occurs that this was not the case. Section 3191 provides that if any question of law arises on a trial in a superior court, the court may, of its own motion, or at the request of the prosecutor or accused, reserve that question for consideration by the SCA. There is nothing in this language to suggest that the state may only request a reservation of questions directed at the conviction or acquittal of the accused. May I stress that, my lady? If the court will ask me, what is the most important thing in Basson? I'll say this one line. There is nothing, my lady, 621 at C. There is nothing in the language to suggest that the state may only request a reservation of questions directed at the conviction or acquittal of the accused. So, my lady, if that is taken into account, sequo is irrelevant. Whatever sequo thought about a conviction has become irrelevant by the way that the Constitutional Court interpreted Basson. Section 3192 indeed strongly suggests that the legislature intended to permit an appeal against any order upholding or dismissing an objection by way of a reservation of a question of law. Now, my lady, my argument is, why would the Constitutional Court refer to the interpretation in line with the Constitution, the duties of the state, and then say a question of law directed at either conviction or acquittal? Then, my lady, in fact, sequo has become irrelevant. Then, my lady, may I then, whilst the court has it available, at page 622, my lady, at C, the court summarized its view of 319. In our view, section 319 should not be construed so as to prevent an appeal against an order dismissing or upholding an exception. The section should be construed so as to allow the state or accused to appeal against an order upholding or dismissing an exception. Such construction of section 319 brings it within constitutional bounds by recognizing the right of the state to institute criminal proceedings and, if need be, to appeal an adverse finding on a question of law. Not appeal an acquittal, appeal an adverse finding, which could be either acquittal or a conviction, because that's what it said. My lady, we then argue that our hurdle as far as our right to appeal, because there was a conviction on a competent verdict, is not a hurdle anymore. But, my lady, may I say, and I say it with the utmost respect, my lady, I do not have to convince this court that I'm correct. I only have to convince this court, my lady, that there is a reasonable prospect of success, that the state may convince the SCA to hear this appeal, even when there was a conviction on a competent verdict. And that, my lady, with the utmost respect, we think has become clear. My lady, on the second hurdle, what's the time? On the second hurdle, my lady, we dealt with much earlier in our heads. The second hurdle, my lady, would be that the court will not refer a question or will not reserve a question of law for the SCA to deal with where it's mere academic and will not have any impact on the finding of the court. We say, my lady, that at paragraph 3 of our heads, my lady, we say, my lady, at the second paragraph, it's our respectful submission that a positive finding on any of the questions proposed, that we proposed, would lead to a finding that the accused should have been convicted of murder on count 1 and should have been convicted on a contravention of section 90. Then we deal with that, my lady. We say, if the court has wrongly applied the principle of dolus provincialis, a conviction of murder would be inescapable. If the court erroneously excluded the portions of the circumstantial evidence and erroneously evaluated the circumstantial evidence in isolation, the practical effect would be that a different court, or the Court of Appeal, would then be in a position to evaluate the position of the fans, the denim that was on the duvet in the room, position of the deceased where she was shot, and if that all is taken into account, the only possible version, if that is taken into account and weighted, my lady, is that the accused version was not only inconceivable, but in fact impossible. So, my lady, we say that the court erred there. My lady, may we just, whilst I'm thinking, we'll get to that when it's questions of law and fact. I'll just proceed here. My lady, our question about the evaluation of circumstantial evidence wasn't challenged in detail by the respondent in their opposition. Because, my lady, we say it's clearly a question of law. If the court applied the principles of circumstantial evidence wrongly, that can only be a question of law, and as well as the evaluation of multiple defences and one specific offence being elected by the court and constructed. My lady, the biggest opposition, if I read the papers of defence, would be, are we dealing with questions of law or fact? I don't know. The court made certain factual findings, and the court listed those factual findings. My argument is the following, lady, that I've read Nzimande, I've read all the cases. But, my lady, in a matter like this, where the court looked at the facts and applied legal principles to the facts, the application of those legal principles to the fact is a question of law. The court said, my lady, in the judgment, at page 3329, the court refers to the test for the reasonable man and then applied the principles or the test to the facts. Now, my lady, we say in paragraph 13, if the facts were the following, and it's a hypothetical set of facts, but if it was the following, if the accused walked into the bathroom, saw the deceased, pointed the gun at her head and fired 4 shots, and he was then convicted of culpable homicide, would the finding that he acted negligently and not with intention, would that be a factual find? Lady, that cannot be a factual find. It must be a question of law. Application of the tests, the subjective or objective test, to the facts. Maybe if a court would, in the example we use, convict somebody of culpable homicide, I say with the utmost respect, we will all agree that that was an erroneous application of the law to to that fact. My lady, now if that is so, if one argued that to the one extreme, then why is the application of the law to the accused, where he fired 4 shots through a closed door, not exactly the same? There cannot be 2 sets of evaluation. My lady, then, in the nick of time, the appeal court gave decision in the Brown matter. We've attached the Brown matter, and where the court again dealt with, and in fact quoted Snyman's definition of dolus eventualis, and we quote extensively. May I just quote at paragraph 15? Person acts with intention in the form of dolus eventualis if the commission of the unlawful act or the causing of the unlawful result is not his main aim, but he subjectively foresees the possibility that, in striving towards his main aim, the unlawful act may be committed or the unlawful result may be caused. And he reconciles himself with it. I think what's more important, my lady, is if one turn the page, and where Snyman is quoted at page 185, if excess dolus eventualis, it is possible that he may, in the eyes of the law, have the intention to bring about the result, even though it does not wish the result to follow. Now that's important. He has dolus eventualis, he has intention, even though he does not wish the result to follow. So, my lady, and clearly we'll say that the court erred in not applying the principles of dolus eventualis, because this is perhaps what happened, that on any construction of the facts, if he did not want that particular result to follow, that would not affect his dolus eventualis. Well, later we say that in application of the test for dolus eventualis, we refer to Malinga. We know that the court, Malady, and I say it with the utmost respect, the court also referred to the foreseeability test and also indicated that one should not, in the comfort of court, evaluate the foreseeability. One should be closer to the action and evaluate the foreseeability. But if Malinga is correct, where Malinga said, on the question of intention to kill, they may have foreseen and therefore by inference did foresee the possibility that the use of a loaded firearm would have fatal consequences. Now, my lady, then more so in this particular instance, where an accused, and that's a court's finding, trained in the use of firearms, or knowing how big that cubicle is, knowing there's a person in there, intending to shoot at that person, why would this person not have foreseen that the use of a loaded firearm would have fatal consequences? Lady, I say it with the utmost respect. I just say, my lady, that the court applied the principle of dolus eventualis in terms of the fact that he must have foreseen that it could have fatal consequences wrongly. My lady, it's also not, as the court, and I say that with the utmost respect, my lady, it's also not, as the court have found, it's also not, my lady, what we have in this instance, my lady, as far as the application of dolus eventualis is concerned, and we cannot ignore it, is the court's finding, my lady, that when he armed himself and walked towards the bathroom, he had the intention to shoot. Now, my lady, and then when he stood in front of the door, he had the intention to shoot, knowing there's a person inside. Now, my lady, we say with the utmost respect, if you apply the principle of dolus eventualis, if he did not, a finding that he foresaw the possibility, or that he wanted to shoot and kill that person, is not important. That he foresee the possibility that it might have had consequences, fatal consequences. If not, my lady, if he intentionally fired, what was his intention then? The court never dealt with that. He stood in front of the door. The court said, and I deal with that page at paragraph 19, the accused had the intention to shoot at a person in the toilet. 3.3. And then the court relies on his ipse dixit. He never intended to kill that person. My lady, then we ask the question that, but in terms of dolus eventualis, what was his intention? Just to fire shots? The court never dealt with that, my lady. But certainly, with utmost respect, if the court indicates that he had the intention to fire at that person, but he said, because the court, although the court rejected his version, and we'll get to that later, the court rejected his version. The court said he was a lying witness. But in this particular instance where there's one action, the one action is firing shots. Now the court made a finding, my lady, and we say, utmost respect, earnestly, that in this one action, he had the intention to shoot, but never intended to kill that person. And my lady, if one applies the principles of dolus eventualis, and the court said his intention was to hurt that person, then there's different arguments. And arguments would be, but if you hurt somebody with a fatal gun, and so forth. But the court never did that. We argue that as a legal question, the Court of Appeal is likely to find that with the proper application of dolus eventualis, based on the court's fact, he went there to shoot at this intruder. The accused foresaw the possibility that 4 shots fired from a powerful handgun may kill the person, and he nevertheless recklessly proceeded. My lady, may we also, we deal with that at page 20. We respectfully submit that another court applying the principle of dolus eventualis will find that it is inconceivable that he had any other intention but to kill that person, or at least accepted that he may. Because that's all, my lady. Accepted that he may. It's not intention to kill, because that's dolus directus. Accepted that he may. That for dolus eventualis, that is sufficient. Now, my lady, what would his intention have been if it's not that? Which makes it even more difficult, my lady, is where we have to take into account that the court is finding at page 3325. The starting point, once more, is whether the accused had the intention to kill that person behind the toilet door who mistook for an intruder. The accused had intention to shoot at that person in the toilet, but states that he never intended to kill that person. In other words, he raised the defense of putative private defense. Now, my lady, with the utmost respect, and we say it with respect, that's not the test for for putative defense. In putative private defense, the accused would think there's an attack on him and act against the attack. And would, in fact, have the intention to shoot that person, to shoot the person that's attacking him. to say that he never intended to, because he says so, my lady, with the utmost respect, is an erroneous application of dolus eventualis and the defense of putative self-defense. The question should have been, my lady, if at the time he had the intention to unlawfully kill the person in the bathroom. Now, if that is so, then that would have raised further questions, and that is, did he, if his intention was to unlawfully kill, did he also at the time realize that perhaps he's too aggressive? He could deal with the situation in any other means. He could move away. He shouldn't fire 4 shots. But those, because of the fact that the court asked the wrong question, those questions that should have been asked was never asked. And therefore we say, my lady, that it was erroneously applied. My lady, then may I refer the court to page 3327. And that's the point in question. I now deal with dolus eventualis or legal intent. The question is, did the accused subjectively foresee that it could be the deceased behind the toilet door? Notwithstanding the foresight, did he then fire the shots, thereby reconciling himself to the possibility that it could be the deceased in the toilet door? Now, my lady, with the utmost respect, we argue, and that's our understanding of the law, and we say that there's a reasonable prospect that we may convince the appeal court that those are not the questions that should have been asked. It should have been, did the accused subjectively foresee that he could unlawfully kill whoever was behind the toilet door? Because, my lady, although the court dealt with error in persona, error in objecto, in this passage at 3327, in dealing with dolus eventualis, the court followed it up by saying, on the contrary, the evidence shows that from the onset the accused believed that at the time he fired shots into the toilet door, the deceased was in the bedroom while the intruders were in the toilet. This belief was communicated to people. But certainly those questions, I say it with the utmost respect, are not questions that should have been asked in terms of dolus eventualis. Because as far as the deceased is concerned, and him knowing that she was in the bathroom and him wanting to fire at her, that would have been dolus directus issues and not dolus eventualis issues. And more so, my lady, at 3327, the court did not deal with aberratio, error in objecto, my lady. Then, my lady, at 3328, the court asked the question at lines 14, did the accused foresee the possibility of the resultant death, yet persisted in the deed reckless whether death ensued or not in the circumstances of this case? The answer has to be no. How could the accused reasonably have foreseen that the shots he fired would kill the deceased? Clearly, he did not subjectively foresee this as a possibility, that he would kill the person behind the door, let alone the deceased, as he thought she was in the bedroom at the time. My lady, again, the reference to the deceased, we say was an error, and if the court dealt with error in objecto, the court applied those eventualis wrongly, in that if he acted with putative private defense, the court would, and without an accused saying, I wanted to kill that person to ward off an attack, or I thought there was an attack, because that's putative self-defense, I perceived there was an attack, and I fired the shots at that person to ward off the attack. That was never asked, dear my lady. But that we say with the utmost respect, my lady. that came in because the court accepted one of a plethora of versions, which the court was not entitled to do. If the court accepted that his version, that he never wanted to fire a shot and that he acted on an impulse, if the court rejected everything and said, but his version was reasonably possibly true, that one can argue is in terms of the case law. But, my lady, to reject his version, not only did the court have to reject his version and accept a different version, but the court had to, on a different version, my lady, construct a version, construct a defense, because he never said he wanted to shoot. So the court had to construct a action by the accused in terms of private defense. It wasn't the application of the law, but the construction of a defense. And we say, my lady, and that was clearly with the utmost respect, because of the multiple defenses and the election of a defense, which the court should not have done, with respect, which the court erred in doing, my lady. We saying, my lady, what the court should have done, with the utmost respect, is accepting or rejecting the accused version. His version is untrue, cannot be reasonably possibly true, and he cannot rely on mutually destructive versions, and the court will not even give effect to his mutually destructive versions. And if that was done, my lady, the decision would have been different. My lady, may I say, and I referred at paragraph 24, where we deal with the erroneous application of the acceptance of of his defense and or the application of circumstantial evidence, it is akin to the situation that happened in Mtswene's case at paragraph 24, where the court said, if the court mistakenly did not call the evidence of a ballistic expert, that is a question of law. But this case is interesting. What happened here is the state did not call the ballistic expert. Neither did the defense. The court then made findings. There was an appeal on a question of law saying that the court should have called that ballistic expert as evidence, as a witness. The court did not in terms of section 186. There, the appeal court in terms of 319 found that that was an error in law. We're saying, well, the court should have taken account of all the circumstantial evidence in the room. I know that the court said that for purpose of the court's judgment that the court had in mind, the court viewed the circumstantial evidence of the condition of the room, and as the court framed it, the not interference by the police, by lack of a better word. The court did not view it as important. We're saying that was an error, my lady, that the court should have. My lady, now, we're saying that factual issues are issues that somebody can see, recollect, be able to give the court a version of what they've seen. Those are facts. The facts are he walked, he shot, the door had 4 bullet holes in it, the deceased was lying there. The interpretation of the law, if he had intention or if he acted negligently, can never be a factual issue. I've looked at Nzimande. And I know that the defense will argue extensively on Nzimande. And Nzimande, my lady, is the creation of false claims. So I create a claim, and my claim, what is my intention at the moment? So I do things and I hand them in. And that is part of the facts. Is what was my intention when I claimed It's different. It's just facts. There's no witness that would ever be able, no, I'm not saying ever, my lady, but it's very unlikely that the witness will come to court and say, I know that person had the intention to shoot. It's always an inference from facts. And the inference from fact is a finding, not a fact. I think where the argument perhaps was made in the past is, if the court uses legal tests or the law and the court makes a finding on intent, that's a fact. But clearly that cannot be, my lady. It is so clear to me that if there's a set of facts, one needs to apply the law to those set of facts to understand what crime was committed and if the accused had intention or if it was only negligent. My lady, it's, I think it's Mahmoud. Yes, Mahmoud, my lady. May I refer the court to Mahmoud? We have a bundle, made a bundle available. There are two things in Mahmoud, my lady. In Mahmoud, we deal with that in paragraph 23 of our heads. At 781G, the court found the considerations set forth in the previous two paragraphs led the court to conclude that the decision of the trial court to exclude the evidence of the aforementioned railway police officer was wrong, and that there were sound reasons for holding it to be admissible, even though it was self-incriminating and the officer had been cautioned in this regard. Clearly, my lady, the exclusion of evidence or not taking into account of evidence is clearly, in Mahmoud case, a question of law. Whilst we're at Mahmoud, 779, my lady. The court found it's a genuine question of law for the purpose of a reservation of a question of law in terms of Section 319 of the Criminal Procedure Act, whether the proven facts bring the conduct of the accused within the ambit of the crime charged. Such a question involves an inquiry as to the essence and scope of the crime charged by asking whether the proven facts in the particular case constitute the commission of the crime. This is clearly a question of law. My lady, we have the facts. The accused walked, fired 4 shots, killed the deceased. And if one applies the law, there's no other reasonable inference that that would be murder. Now, why I'm quoting this, and this is just that Mahmoud went as far as to say that that is a question of law and not of facts. My lady, whilst I'm dealing with Nzimande and Mahmoud, my lady, Nzimande and Mahmoud, they refer to the case S versus Petro Lewis, 78 TPD. Now, my lady, we looked at Petro Lewis to understand why the court would think that, or why the court would argue and make a finding that the question of intention and or negligence is a question of fact. Because, my lady, and I apologize if it's so clear to me and if I'm wrong, But, my lady, clearly, intention, although I read the cases, but intention on what somebody did, he walked there, he did that. Intention is when the court sat down and we argue for hours with all the case law to try and convince the court that there was intention and or negligence. That's not a fact, my lady. That is a finding. Now, then we said, but why did they, with reference to Petra Lewis, why did they make the finding? And, my lady, and the only real reason we could find is, and it's clear in this matter, the court said that inferences are matter of facts. The court said to find differently would just open the doors to appeals. Therefore, inferences is a matter of fact. If I'm correct, that's my interpretation of it. If I'm correct, that finding was based on the court's concern that it would open the floodgates for appeals if every inference on the facts could be taken on appeal, then clearly, my lady, it is not well-based. And it's also insignificant at the moment because, my lady, we refer to, and I'm sure it's knowledge, but we refer to the Law Commission's statute that is now serving before Parliament, wherein they want to extend rather than curtail the state's right to appeal. Now, lady, if that is so, then the atmosphere has changed. There must be a reason, my lady, but the reason why the court would say that a finding is a factual issue. I'm not saying a finding is not a fact. If the court make a finding, that's a fact. But it's not a factual issue. A factual issue is what happened. So, my lady, that is my argument as far as that is concerned. What's the time now? My lady, I'm going to ask for a adjournment, but I just say, my lady, this is a complicated argument. And I know that over here the same thing happened. As soon as the state appeals in terms of 319, the opposition would be it's a factual issue. I mean, my lady, that happens. And I think the cases where the court in the Eastern Cape said that it's high time that the state has a right to appeal on facts because the court said it now got tired because of all these arguments. But I know it's a complicated issue. And I still have to deal with count 4. And I still have to come back to other issues. But just for me to gather my thoughts, may I ask that we take a tea adjournment, nothing more than 15 minutes, my lady.
What's your time?
I have it 6 minutes past 11, my lady. Shall we make it 20 past, my lady?
No, we'll be back at 11:30.
30.
Yes.
Yes, Miss Sim.
That's a good pieces, my lady. Lady, may I just refer to paragraph 54 of the papers in response by the respondent, and I'll read what is contained in that paragraph. It's indicated there that section 3192 was amended to permit an appeal by the state, probably as a result of the Constitutional Court's finding in Basson, was amended to include references to indictment, but was not amended to permit an appeal by the state on a question of law. But it's clearly wrong. That section was never amended after Basson. It was applicable in Basson. If one reads at page 821 of Basson, it's clear. 621. In 621, in Basson's case, they refer to section 319 in exactly the way it's framed at the moment. So, before I carry on with this argument, I had from my learned friend, they agree I'm right. But it was never, that Basson never caused an amendment, and to say that why did they not amend the other sections as well? Why did they not include an appeal on conviction by the state? So that point should not be taken into account. My lady, as was said in all the cases, it's mostly difficult to distinguish between a factual and a legal question. My lady, the argument we have on inferences from facts as a legal question and not a factual question, we think is valid. We don't have, with utmost respect, we don't have to convince the court, but we think we've got a valid argument to at least for this court to find that there's a reasonable prospect that we may convince the Supreme Court of Appeal to accept the fact that in this particular case, the question of the accused's intention is a legal question and not a factual question. But, my lady, even if the court would feel that that is not a good basis for our appeal, we respectfully argue that we have a reasonable prospect of success in convincing the Supreme Court of Appeal that this court's construction and application of Doris Eventualis as applied to putative private offence and error in objectum, my lady, was erroneous. And on that basis, we argue that we have a reasonable prospect of success on appeal. My lady, I am almost done, and I'll deal with count 4. If there's just one or two things in the heads of argument that are marked. The fact that it's usually difficult to distinguish between questions of law and questions of fact, that fact was mentioned in the Mahmoud versus Janssen van Rensburg matter. I just think it's common sense, my lady, that in a court where there are facts and inferences and findings, that the line of distinction between the two would be very thin. We have, when I argued earlier, referred the court to the portion in Mahmoud where we said that such a question involves an inquiry as to the essence and scope of the crime charge by asking whether proven facts in question constitute a crime. I referred the court to that portion at 799. If we use that, and that is the last paragraph under our paragraph 21, we say that perhaps that is the essence of the question we argue, whether proven fact constitutes the crime of murder. But we think that is too wide. We have to narrow it down. And we say we narrow it down to the application of the principles of dolus eventualis. My lady, I am fairly convinced that there will be argument that what we're trying to do as a state is that because we're unhappy with the findings of fact, we're trying to mask our argument to be questions of law, where in fact it's questions of fact. My lady, clearly we argue differently as far as the facts are concerned. That's a fact. And I cannot stand here and say that perhaps we're not 100% in agreement with the court on the factual findings. But my lady, we really, in our application and in our argument, are convinced that the points we made are not points of fact, but points of law. Then, my lady, as far as count 4 is concerned, in count 4, we do not have the sequi hurdle because there's an acquittal. In terms of sequi, in terms of Basson, the reservation of a question on acquittal is possible. My lady, we, however, say that the application of the law to the facts as far as count 4 is concerned, was erroneous. In paragraph 49, we listed the facts that the court found. The accused was sufficiently trained in the handling of firearms, and that would include the responsible handling of firearms. The ammunition was found at his house. He did not possess the ammunition found at his house. The ammunition belonged to his father. We refer to SABC, where SABC indicates, although SABC, my lady, deals with possession of a machine gun, the definition of possession in terms of the Act deals with possession of machine guns, possession of ammunition. It's just possession for purpose of the Act. Now, SABC clearly indicates that mere custody of a machine gun would be sufficient. We say mere custody of ammunition would be sufficient. Menisi, again, discuss the section 336, and with reference to Potwane, indicates that either negligence or intention would be sufficient culpability to be convicted on this count. And then at page 254, my lady, the court said, with reference to section 2 and 36, it's immediately apparent that the legislature has not used words such as willfully, unlawfully, or maliciously possess. Just mere possession. My lady, we're saying that the court's decision in this particular case will have wide implication for the owners and possessors illegally or legally of firearms and ammunition. We say, my lady, that as far as a conviction on count 4 is concerned, the ownership of the ammunition is irrelevant. The fact that the accused had it, the mere possession of it in his safe, is sufficient. But lady, because if one uses the argument, it would mean that I'll be within my rights to hold a firearm in my safe of anybody, which is clearly not so. In terms of the Act, everybody needs a safe. You need to have a gun for your own safe. You go through strenuous inspections about firearm safes and so forth. But, my lady, if the court is correct that the accused was not in unlawful possession, then anybody in this country, with the utmost respect, would be able to keep firearms and ammunition on behalf of each other. And the error is, my lady, that the intention that we argued and that the court found relates to possession. In the finding of the court, the intention was to possess, and the court did not make a finding on the form of fault that would be sufficient for this offence. And the form of fault, we say, sufficient would be negligent. If you're negligent, find yourself, or if you're negligent on possession of ammunition, you contravene the Act. Mere possession of the Act is what's important, my lady. My lady, we say it could never have been the legislature's intention to allow people to have in their safes ammunition and firearms on behalf of other people if they never had a license for it. Lady, it cannot be an offence with the utmost respect to say it's not mine. It's there in my safe. I know it. Gave permission for it. I knew it, at least. I knew it was there. And to say, but that would not constitute a contravention. But again, my lady, we cannot appeal on questions of fact, only on questions of law. We say that erroneously the court did not find that mere possession and negligent possession of ammunition constitute a contravention of Section 90 of the Act. And therefore, my lady, this question should, with the utmost respect, be reserved. My lady, that's the state's argument on Section 319.
Thank you. Thinking snap. Yes, Mr. Roux?
Thank you, Madam. We have not submitted formal aids, and the reason being that we drafted the opposition also in the form of aids, if you would accept it as such. My lady, I accept that you have seen the opposition. I'm not, the two documents, I'm not going to deal with it in detail. This is an application for leave. I'm simply going to highlight limited points. Yes. As to the sentence, my lady, you will see if you take the state's application, in every single paragraph where the state alleged that there was a failure by the court, we in fact give the paragraph numbers to show that it's not correct what the state is saying. If I may refer you to page 4 of the respondent's opposition relevant to the sentence, you will see that, my lady, we deal with the first and second bullet points. We say there's the record. The court dealt with that. The same with bullet points 3 and 4. And so we go right through on every point, without exception, every single point raised by the state in its application, why the court erred and that the court failed to take into account. We show in the record that the court in fact took those factors into account. And it's not good enough with respect then to make the submission to say another reasonable court may come to a different finding. The test is different when it comes to appeals on sentence. It is the starting point is that the court's judgment is a value judgment, that it's acknowledged by our legal system that the trial court is in the best position to decide on an appropriate sentence. And it is only where there is a material misdirection or where it can be said that it is shockingly inappropriate that there may be interference by a court of appeal. And what we have done, my lady, we have taken the time in our opposition to deal with every point where it was contended that there was a misdirection, to show that it's not so, that the court in fact took that into account. And on that basis, it cannot be said that there's a reasonable prospect in view of the strict test when it comes to sentence. We have dealt with that test. I'm not going to repeat it in paragraphs 1 to 4, saying exactly what I've submitted to you to say. You cannot simply say that another court may come to a different finding. It's different. It is another court having regard to the fact that a trial court is there to give a valid judgment and sits in the best position. Then only you have to try and find material misdirections, and they're not there. Every aspect complained of by the state was negated in our heads or our opposition by saying, but the court dealt with that. The last part that's important, the state says, but it's only 10 months. It's not. The state quoted the relevant section, and it says, if I may say, it is say, what will happen after 1/6, it may not consider the release before 1/6. It says, before being considered under placement on correctional supervision. So all it says is that is the time, the first time, that you may consider it. You may not consider it before the 1/6. Thereafter, once it has arrived, that period, then only you may consider it. And it's discretionary. It depends on various things that's outside the position now. And I think the court was acutely aware of that. So it's incorrect to say that it's a light sentence. It's not. And if and whenever he's released, then he goes on correctional supervision. He's not unconditionally released. That is a difficulty with Section 2761I. Then you go, in effect, to Section 2761H. So it is not that light sentence that the state tries to make it out. And we say there's simply no prospect of success. And more importantly, the state has not made out a case. My lady, I've omitted, we have, insofar as it's important, we have also just put the case law prepared bundles for you. I omitted to hand it to you. Now, my lady, dealing with this application in terms of Section 319, the state started off by SABC, and may I make this submission? SABC does not come up for consideration because the state must first get over the first hurdle and persuade you that it's a legal point for reservation and not a factual point. It's not for the state to get over some hurdles as put by the state. It must first get out of the starting blocks. And I will show to you the case law on intent, making it clear it's a value judgment by the court on the facts. Not only Mahmoud case, not only Mtsweni case, all the cases, and I will refer you to that. And then I will refer you to your finding and show that what we're actually dealing with is academic debate in the event if the finding were to be X. It's not the court's finding. So the state has a difficulty. But may I, just to explain our understanding of SABC in any event, because we don't get to SABC, what actually happened in SABC is that the court had to decide, in view of previous cases, whether the state can appeal where there was not a complete acquittal, where he was convicted on a competent verdict. And I've heard now a new interpretation of competent verdicts. Not important. And the reason for that is the following. It's very different. My lady, it says in Section 3, and I will be very quick on this, it says in Section 322(1), it says, in the case of an appeal against a conviction or of any question of law reserved, the court may then do certain things. But then, it specifically deals in subparagraph 4 with the present case, where it says, in sub 4, where a question of law has been reserved on the application of a prosecutor. Now it refines it in the Act in Section 322. In the case of an acquittal, and the Court of Appeal has given a decision in favour of the prosecutor, then it says it goes to 324. The procedure that should be applied is 324. And the reason for that is the following. That it should be common cause that you may not, the state has no right to appeal against a factual finding, even if it were to be wrong, and we say it's not. But even if it's wrong, and we will refer you to cases, because you have no such right, and it's true in a commission, they look at it and say, should we not extend the rights of appeal also to questions of fact? We're not there. That's not our law. It may or may not come. I don't know. We can only deal with the court law the way it is. Now, what the state then submits, it says, well, I know the respondent is going to say I mask questions of law and convert them into questions of fact, to convert them into questions of law. Of course he does so. And may I just take you to our document, Respondent's Opposition. And let's look first at the case law. If I may ask you, my lady, to go to page 13. I'm going to take you to 3-4 different binding cases, SCA or AD cases. Page 13, you will see there's a reference to Mahmoud. It's page 811, A to D. And it doesn't matter that it relates to common purpose. It talks about inferences. Now, where do we get inferences? We get inferences in criminal matters and in civil matters. You draw it either on a basis of circumstantial evidence or you draw it on a basis of direct evidence, but mostly on circumstantial evidence, which is this case. That's when you draw an inference. If you see the man shooting another man, you don't have to draw an inference, but sometimes you have to when it's circumstantial evidence, which is this case. So it talks about inferences, and if I may read this, and the court says of appeal, I've no doubt that an inference drawn from proven facts, and may I just stop here, my lady? A proven fact is not a fact that was before the court. A proven fact is a fact found by the court to be the proven facts for purposes of the judgment. Any fact is not a proven fact. We have many facts not accepted by the court. A proven fact would qualify to be a proven fact as a fact that the court found to be worthy to base the judgment on. That's a proven fact. It says, I have no doubt that an inference drawn from proven facts that the accused had by agreement formed a common purpose. That's not important because it's the same principle, which embrace, say, the possibility of an unlawful killing. It tells us what it is. It says it's an inference of fact and not one of law. It is a secondary fact. It is seldom in a case of murder that there is direct evidence of the perpetrator's actual state of mind. Consequently, where the unlawful killing was accompanied by dolus in one of its forms on his part is normally a matter of inference from the primary facts. Clearly, this is an inference of fact and any question as to whether the trial court correctly decided this issue is a question of fact. And it carries on to explain it, but it's not important. It's there for your reading, my lady. Then it goes to the next case, in the next page, page 14. It's Slubbert and Prinsloo in the appellant division. It says, paragraph 30, a question as to whether a particular conclusion of fact can properly be drawn from a proved set of circumstances. That's our case. Is one in the answering of which an utter ignorance of law is no disqualification. The question whether the proved facts justify the inference that the accused killed the deceased can be answered by a person who has reasoning powers but has never seen the inside of a law book. It is a question of logic and not of law. And it goes on the next page, page 15, paragraph 31, where it's underlined and it says, and another court, where he warns, he says, and another court seized of the case on the merits may well have concluded that these strong indications taken in conjunction with the failure by the accused to enter the witness box were cogent enough to secure a conviction of the respondents, or some of them, and that's the important part. These considerations must not, however, be allowed to obscure one's perception of the legal and policy issues involved in permitting Section 319 to be utilized in the manner the prosecution, in this case, wishes to use it, or to weaken one's resolve to maintain what appears to be sound legal practice. And then it goes to Nzimande in page 32, again the same, where it deals with intention. And it says, this required an inference to be drawn from the primary facts already found. Any inference so drawn was a secondary fact, not a question of law. And it deals with that on the next page, where it says, again, thus the state's complaint was not that the trial court had committed an error of law, but that it had drawn an incorrect inference from the facts. Such an error, if indeed it was one of fact, not of law, and as such did not confer upon the state the right to appeal against the acquittal of the appellant. Accordingly, the appeal court could not entertain it. And the same goes down with reference to the Peter Louis enterprises, and so it goes on and on. Our Court of Appeal has found on a number of occasions that this is a question of fact. Now let's see what the court's factual finding was and why the state's unhappy with that. The factual, and what is so telling, if you read the state's application to have a question of law reserved, the one thing they will not put in the application, one of the quotes from the transcript, is the most important part, where the court comes to a factual finding. And that you will find, my lady, in the opposition document, starting from page 6, paragraph 17. And if I may summarize it, what the court is saying over the next 4 or 5 pages, it goes up to page 9, is the following. With acceptance and rejections of parts of its evidence, a proper approach by the court, and say, I find on the facts, on the basis of your belief and on your conduct, that although you intended to fire the shot, I don't buy the story that you did not intend to fire, although you intended to shoot, that you did not intend to kill and that you did not foresee it. You did not foresee that it would kill. That is a factual finding. Whether that's right or wrong, I say it's right, but it doesn't matter. That's the court's finding. It says that in so many words at so many places, where it says, for instance, page 7. The question is, did the accused foresee the possibility of the resultant death, yet persisted in his deed reckless whether death ensued or not? There's the answer. In the circumstances of the case, the answer has to be no. Circumstances of the case means on the facts of the case. The court says that clearly did not subjectively foresee. on the basis of his belief in his conduct. That's the basis of the finding. Now, the state's unhappy with that finding. Now, they come and they argue dolus eventualis. Here's the question with respect, my lady. If the factual finding is he did not intend to kill, can it ever be dolus eventualis? Whether you apply error in objecto, whether you apply transferred malice, and whatever you want to apply, you don't get to that point, and that's exactly what the court was doing. The court dealt with all the law correctly. The court said, this is what dolus eventualis is. This is my view on error in objecto. But on the facts, in the circumstances of this case, I find A, B, and C. I find that he did not intend to kill. I find, in addition, that he did not foresee that the shots could kill. That's a factual finding. I've referred you to the case law. That's purely a factual finding. Now, on what basis can it be suggested that on that factual finding you can say it's dolus in any form? It cannot be. Dolus in any form is dependent on those prior elements and a different finding. What the state's doing is say that finding, that inferences that you drew, so that's in fact legal. Despite, I've referred you to 4 cases of the SCA or the AD. Despite the cases saying it's not. You cannot appeal. Is it right or wrong that you cannot appeal? That's the law. If the Law Commission wants to change it later on, change it. But this is the law that you're bound to. And if they cannot get over that hurdle, get out of the starting blocks, to say, but it's not a factual finding, and they cannot, because it's contrary to the AD decisions, then they're bound by that finding. And as we've contended, you cannot find dolus eventualis on your factual finding. It cannot be. And my lady, you absolutely correctly dealt with dolus eventualis. There's the definition, there's the case law, that's what it says, but on the facts, I cannot find it. And the state must now twist it to say, and I was trying to understand and come with a long argument what dolus eventualis can be. We know what dolus eventualis is. To say, but actually your inference that you drew on the facts, that's a legal conclusion. It's not. The case law tells you it's not. I've referred you to the cases. They say it's not. So it's a factual finding. They don't get out of the starting blocks. That's the end of a case premised on 319. The scope is limited. We've referred you to all the cases and say that's what the state can do. Only if it was a legal question of law, then you look at the Sekou case. We don't get there at all. So what we say, my lady, and it's not what the state is saying to you, that another court may reasonably be inclined to answer the question in the affirmative. That's the second step. You can only reserve a question of law if it is a question of law. Once you find, and that's the case law, once you find it's a question of law, then you have a discretion to say, well, is this going to make a difference ultimately? That's where the discretion comes in. And that's where another reasonable court may differ and may come to a different finding. But they must first establish that it's a question of law. If not, you don't get to the second question that the state tries to get to. And it's the end of that matter. My lady, insofar as it's necessary, I've looked at the heads of argument, paragraph 13, if I might take you to this, to demonstrate what the state's doing. They say we respectfully want to illustrate our arguments by means of hypothetical set of facts.
What paragraph?
It is paragraph 13 of the state's heads.
Yes, I've got it.
They say if the facts were, my lady, proven facts are facts found by the court for purposes of the judgment. I don't have to read this. These are not the facts. Let's go to the next paragraph where they come in the principal approach to 18. To their paragraph 18. They say, another court may find that when the accused armed himself with a loaded firearm and walked towards the bathroom with the intention to shoot, he already foresaw the possibility. The court made a factual finding that he did not. So another court may not find it. It's not whether there's a possibility, if another court may find that. He may not. That is the limitation in 319. And that's why I read to you the passages by all those judgments saying, even if the trial court's wrong, even if it's a serious mistake of fact, we cannot interfere. That is the limitation of section 319. So it's interesting what they say here. But it is an attempt to change the factual finding, or to take a factual finding and say, let the court of appeal reconsider your factual finding, and found that you're actually wrong. You should have found, not on the facts that it's A, you should have found B. You may not do it, my lady. The next one is page 44. Paragraph 44, I apologize. It says, and that sums it up, my lady. Interpretation of section 319 and 3224 are in line with the Law Commission's proposal that would permit the state to appeal questions of law and fact. Yes, let us get there, my lady, one day, if it happens. I don't know. On count 4, I thought that the court was at pains to explain it, and I thought it was correctly explained. You have to distinguish between two steps. Step 1 is to look at the meaning of possession. And then step 2 is when you come to the fault element, to say, well, should you interpret this with, it's a statutory offence, with intention or negligence? We know on the Firearms Act, negligence will suffice. We know that. That's not what it was about. The finding of the court dealt with the first leg of the meaning of possession. And that's Kwandu's case, the SCA's case, saying it consists of two elements, the attempt and the you fall short on it. That case. The one is, it is a case dealing with sentence. And the court, and I think it's a highly unfortunate remark when it remarked to which include mere custody, because it's not correct. But it's not in the context of deciding the possession element. It's on sentence. It was just a reference, obiter, which include mere custody. Secondly, and it's contrary to the Kwandu, but it's a finding on sentence. It's obiter. It's a reference. It's not even obiter. Secondly, in the 1969 Act, there was a definition of possession. That is not included in the Act that the accused was charged for. That definition of possession is not there. You're back with the common law definition. It was not repeated from the 69 Act into the 2000 Act. So that case, in any event, referring to a definition, does not assist. And that's the difficulty, my lady, is that the court's finding is now stretched as if the question of law should be culpability. That's not the court judgment. The court judgment is if you don't overcome the first hurdle on possession, then it's the end of the case. And that was the court's finding with reference to the SCA case. And that's the difficulty that the state has. But in any event, to explain the state's contention in today, if it's mere detentio, it means that I go into your house, I want to be safe, I want to put my firearm in your safe for the evening, that little children running around. The owner of the house must be convicted. Would that, because it's mere detentio and not the animus to possess? That's not our case law. That's what the state's submitting to you. It's not our case law. So we say there is no legal point there. It is wrong to try and introduce the culpability element where the court dealt with possession. We respectfully submit, my lady, that all our arguments are contained in opposition, but I've highlighted it There is just no way that the state can overcome the problem of a factual finding. I was reminded, there was another statement by the state, a contention made. It says that the court incorrectly applied the test relevant to circumstantial evidence. My lady, I don't even have to go there. You absolutely correctly say this is the law. And what you said was absolutely in accordance with S versus Blom. You said this is the law I must approach, circumstantial evidence. Their problem is they don't appreciate your factual finding on it, and now say that it's incorrectly applied, circumstantial evidence. Your legal exposition is absolutely what the law is, and I will ask them to read your judgment and to say what part of your judgment on the legal position is wrong. It's not. It's the same with dolus eventualis. You correctly quoted a case, say this is what it is, but your factual finding took you outside the ambit of what the state hoped to achieve at a trial, and that it's not a question of law. I don't know if there's anything else, my lady. But for on the leave to appeal on sentence that we're entitled to cost in terms of the statute, it's in the court's discretion to consider that. It's not provided for in section 319, strangely enough, but only in respect of section 316. It is specifically provided for in 316 that if you dismiss the application, that you can order the state, like in civil matters, to pay the cost of this application.
Thank you.
Thank you.
Thank you very much. Is there anything?
Apologies, my lady, I didn't hear.
Is there anything?
No, I have nothing.
Thank you. Thank you. I'd like to thank both counsel. I want to think about it. Are counsel available tomorrow at 9:30?
Tomorrow at 9:30?
9:30.
Tomorrow?
Yes.
My lady. I will be available.
I will make sure that there is something. I'm not here for that.
Court will adjourn.
Emilam, stanno rising one to go